Well, good afternoon and a very warm welcome to this online launch event for the University of London Intercollegiate Refugee Law Clinic. It's fantastic that so many of you are able to join us in cutting the ribbon to formally open this project. For those who don't know me already, my name is Professor David Cantor and I'm the Director of the Refugee Law Initiative. As Chair of the Refugee Law Clinic's Governing Board and on behalf of its members, it's my great pleasure to open this launch event by saying a few introductory words about the clinic. As the name suggests, the Intercollegiate Refugee Law Clinic is a highly collaborative project. It brings together student volunteers from 10 of the University of London's member institutions and pro bono volunteer lawyers from 2 of our city's leading international legal firms, Macfarlanes and Clifford Chance. This innovative project is also supported by local charitable trusts and foundations, and by a range of referring organisations. These productive partnerships among different sectors of our London community are at the very heart of the clinic's work. The work of the clinic is actually twofold. On the one hand, it provides hands-on, high-quality clinical legal education in refugee and human rights law to the volunteer students and pro bono lawyers who run the cases. On the other, it addresses a major gap in the legal landscape in London, providing unrepresented asylum seekers with legal advice and representation on their fresh claims for asylum. The scoping study, which we did prior to setting up the clinic, identified this as the area of greatest legal need locally, and the clinic aims to establish itself as a national centre of excellence on fresh claims for asylum. Returning to the present, we're really delighted to take the chance to formally launch the Intercollegiate Refugee Law Clinic today. But in fact, today's launch is as much a celebration as a launch. Indeed, the clinic actually opened its doors last summer, in the very middle of the pandemic, a challenging experience, as you'll hear in just a moment. Although it started work remotely during these lockdown conditions, the clinic nowadays operates partly remotely and partly in person from a smart set of offices in central London. On a daily basis, the legal advice and representation at the clinic is provided by a small group of staff and almost 100 volunteer pro bono lawyers and students, some of whom are refugees themselves. The broader strategic direction of the clinic is supported first by a governing board that brings together representatives of all the partner institutions, and second by an expert panel of specialist lawyers in the refugee field. A little later in the event, you're going to hear firsthand from both staff and volunteers about what it's been like setting up and running the clinic over the pandemic. But we're off to a really good start. The vital work being done by the clinic and its many supporters has already resulted in it being shortlisted for the Best New Pro Bono Project by the UK Attorney General and LawWorks annual awards earlier this month. For that achievement, many congratulations to all involved. Returning to the launch today, I'd like to round off this short welcome with some standard Zoom housekeeping reminders. Please do keep your microphones on mute and your videos off unless you're a presenter. We will be recording this session and the podcast should be available next week on the website. Let me also direct your attention again to the chat function on Zoom, where you can input your questions and comments during the final panel session, after we hear from invited experts about the implications for refugee law practice of the government's new plan for immigration. Now, to the main part of the event, and to launch the Refugee Law Clinic with short inauguration speeches, I would like to turn to the high representatives of each of the clinic's main partner organisations. Cutting the ribbon first, on behalf of all the university partners, is Professor Wendy Thompson, CBE, the Vice-Chancellor of the University of London. She'll be followed immediately by our law firm partners, Louise Smith, Director of Diversity and Inclusion at Macfarlanes, and David Boyd, Head of Pro Bono for the UK and Ireland at Clifford Chance. Vice-Chancellor, you have the floor.
Thank you so much, David, and thank you to everyone who's joined us today. This is a really welcome opportunity for me to join you in this celebratory event. it's a special thanks really must go to all the people who've made this possible, who we're very appreciative of, all the donors who are supporting the clinic financially that David has mentioned, Macfarlanes, Clifford Chance, Metropolitan Thames Valley Housing Trust, and the Worshipful Company of Drapers. And there's many others who didn't want to be named, but who have also made this possible. Thanks too to our member institutions who have joined in to support this initiative. It very much represents, I think, the value and public benefit that the University of London and its member institutions, have always long brought to its community, and which is well represented in the services being offered by the legal services here being open today. I mean, I think it was one of the early projects really when I arrived at the University of London that I learned about from David, and it's really so it's really great to see it actually coming into existence despite what's been such an extraordinary year. It's very much aligned with the priorities I think I'm bringing to the University of London, which is it's recognizing our important civic role, the importance of a professional legal education that gives our students, and volunteers an opportunity to really engage with real world issues amongst some of our, most important clients who have had such a tough time getting to where they are today here in this country, and who so much need the support of the legal assistance they're going to be able to obtain from the legal clinic here. So, I'm delighted that we've been able to get this to happen, and the pro bono work that we've helped to convene in this area that's really so much underserved in London. So it's a delight to be able to see this need being met, and for our students to get an opportunity to help with doing so. So I won't say more than that. There's an exciting opportunity to hear from others today. I'll just say and finally, a thank you to Louise Zakaria from Macfarlanes and David Boyd from Clifford Chance for their partnership and their confidence in this project. And I think I'm probably handing over straight to them now, if I'm understanding my job from David. Thanks.
Many thanks, Vice-Chancellor. Louise?
Great, well, thank you, and hello, everyone. So delighted to be here on behalf of Macfarlanes. We're really delighted to be one of the founding partners of a really important pro bono clinic. Increasing access to justice is a really important focus for Macfarlanes' corporate social responsibility programme, and incredibly important to our lawyers. It can be really challenging for lawyers in commercial firms particularly to find ways to access meaningful and impactful pro bono work. And so having the infrastructure of the Refugee Law Clinic, which is providing specialist training and ongoing support for our volunteer lawyers, is absolutely vital for us to be able to participate and to give back in the way that we would like to do. So I'm very happy to be here, to be cutting a virtual ribbon as well. And thank you to everyone who's been involved from across the two firms and all of the students. I know the feedback that I've had from people working from Macfarlanes in this clinic has been absolutely fantastic, and they're really enjoying the work, learning a lot, but more importantly, seeing the impact of the work that they're doing. So thank you very much.
Thanks, Louise.
Thanks indeed, Louise. David?
Thanks, David and Louise. Thank you very much for having me today. I think many of us here, and particularly within Clifford Chance, there's been an ever-increasing concern about the pernicious politicisation of refugees and asylum seekers in the UK. And so with that in mind, we are really, really appreciative to be given the opportunity to be able to deploy our legal skills for the benefit of asylum seekers in the UK. I wanted to particularly thank David, Francis and Susie for over the past 18 months, 2 years. We've been working together to develop this project, and I've been consistently impressed with the excellence they have displayed, and it's now coming to fruition and crystallizing into a resource that can be really impactful. And I just wanted to say from everyone at Clifford Chance, thank you for giving us this opportunity.
Well, many thanks, David, Louise, and Vice-Chancellor for cutting the virtual ribbon, and also for your kind words of encouragement. So the clinic is now formally open at last. To share with us how the clinic has in fact been running up to date, let's pass over immediately to the clinic coordinator, my colleague Susie Reardon-Smith, and the clinic's supervising lawyer, my other colleague Francis Trevena, to talk us through the peaks and pitfalls of opening a new legal education service in times of COVID.
Thank you, David. So the Refugee Law Clinic's main legal focus is on advising and preparing fresh claims for asylum, which is the process whereby someone who has already had their asylum claim considered then provides further evidence or detail related to their case. This might be because of changes in circumstances or the laws on the country from which they come, or that they're now able to obtain some evidence that they didn't have when their asylum claim was first considered. The result of a fresh claim can be that someone who is previously a denied asylum seeker can obtain refugee status and effectively start their life in the UK. So it's really important legal work. Fresh claims are also a fascinating area of law for volunteers to learn from, as it involves looking back through past decision-making and legal representations, as well as collecting witness statements and gathering evidence. Clinical legal education, the model that the Refugee Law Clinic is based on, is the opportunity for students to gain practical experience by working on real legal cases under the supervision of a qualified expert lawyer. For our lawyer volunteers, working in the clinic gives them an opportunity to explore a different area of law and develop a secondary specialization along with a range of other skills. Through providing free legal advice in an area of need, clinical legal education projects also contribute to access to justice for some of the most vulnerable members of our society. So despite the many obstacles that the pandemic has created for us all, we were really pleased to be able to start the work of the clinic last year. And we transitioned all of our training and then client appointments online. We responded to the various restrictions imposed by COVID by moving between a remote service and offering some in-person appointments when restrictions allowed. This obviously caused a number of challenges, such as needing to obtain technology in order to sign and verify documents and supporting clients to access various technologies and programs. But our staff, volunteers, and clients have all really adapted to these challenges well. And we're now in a position to offer more face-to-face appointments for our clients, and we hope that we'll be able to utilize our clinic office space a bit more moving forward. In order to prepare our volunteers for work within the clinic, we've developed specialist training that teaches both the law and practice of preparing fresh claims. We've so far trained 55 commercial lawyer volunteers and 45 University of London students, and we'll have a new cohort of volunteers joining us just after the summer. The clinic itself opened for referrals in August of last year. We've so far had 39 referrals and we've started work on 27 cases. The process of preparing a fresh claim submission can be quite involved, as it includes gathering a lot of evidence and drafting detailed statements with clients. But we have now submitted one case and we have a number of other cases that are nearing completion. Volunteers in the clinic have worked on a range of cases so far, including cases with disputed nationality, particularly Eritrean Ethiopian cases, cases with likely trafficking situations, and some cases where there had previously been poor legal advice. The volunteers usually work in groups of 4, with a mixture of both student and volunteer lawyers assigned to each case. At this time, we have over 50 volunteers actively working on cases, and the feedback from volunteers so far is that they enjoy the collaborative nature of the work and working with others both across the university and with our partnering law firms. The clinic has also provided advice to referring agencies on fresh claims and on other referral pathways for particular cases, working towards our aim of becoming a centre of excellence in the field of fresh claims. We also have students working on a number of other projects, such as developing good practice guides for lawyers working on fresh claims, some projects around simplifying information for our client group, and preparing presentations for conferences. I'll now hand over to Francis, who will provide some further detail on the work and the impact of the clinic.
Thank you. So the work of the clinic came about from some research that demonstrated that fresh claims were a particular area of need in London. But actually what we found is our clients are spread across the UK. Partly it's the impact of the COVID regulations, which have led to more people being in accommodation, so they're being dispersed. But it also means that we now have clients across Swindon, Plymouth, Wigan, And we're able to use technology much more adeptly in order to reach out and connect both with those clients and also with the supporting agencies nearby to them. So although we're based in London, we're being able to build a network that's much broader. In particular, actually, other law clinics have been incredibly helpful in providing us with contacts and spaces where we can use video conferencing, speak to our clients and get documents signed. Obviously, the impact of COVID has largely been quite negative across the UK. I think it's made our work harder to imagine. It means that a lot of our volunteers haven't been able to come in or meet people face to face. But it has also meant that a number of our clients are housed, even if that housing is temporary and precarious. Our referral partners talk about giving clients space to think and maybe to work on their fresh claim. The other benefit to our referral partners has been increased knowledge. So working with us on subject access requests and also on what constitutes a fresh claim and how to identify one when somebody comes in with a bundle of papers. We've set ourselves the task of providing specialist information more broadly about fresh claims and becoming a centre of excellence. So it's great that our referral partners feel they can come and ask us these questions. The other people, obviously, who are really impacted by our work are the volunteers. For law students, it's a source of inspiration, insight, and really valuable experience. They've had contact with clients, witnesses in the UK, and in some cases, witnesses abroad. They've also looked at how to instruct experts. And in one case, we've had a volunteer who spent her entire Friday morning with embassy officials. So it's a really diverse range of experiences and dealing with different people that's hugely beneficial for students. It's also been great to see them work alongside lawyers. And the hope is that the clinic builds an interest in and a specialist knowledge of asylum and international protection for all of our volunteers. In terms of our clients, the impact of having no immigration status and having been refused asylum is huge. Our client group is 27 currently, and of those, 1 in 3 have told us that they've had suicidal thoughts recently, and 2 have attempted suicide in the last 6 months. They are an incredibly vulnerable and precarious population. The lack of status here in the UK and the lack of recognition of what has happened to them to cause them to come to the UK has a really profound impact on people's mental and physical health. So when I was thinking about describing what impact it has on them, actually one of our clients wrote to us this week. So I thought rather than me paraphrasing, I would write what he has said, which is, I am very, very grateful. You organise my interpreter and you treat me for everything. I'm very happy. God bless. And I hope that that's a message that our volunteers take away, that their work is really impactful, that even regardless of outcomes, and we hope that for most of our clients, the outcomes will be positive, being able to talk through their cases, to be listened to, and to have that support from volunteers is really important for clients. So I will leave my summary of the impact there and pass on.
Great, thank you, Frances. I'm now going to hand over to Paige Achilles, who is a solicitor at Macfarlanes, and Olivia Johnson, a solicitor at Clifford Chance, to speak briefly about their experience of volunteering at the clinic.
Hi, everybody. So Olivia and I have been working alongside 2 students to assist in an asylum application for one of the clients of the clinic. I am a solicitor in the private client department at Macfarlanes, and therefore the clientele who come to the clinic are very different to those I deal with on a daily basis. As mentioned by Louise, the most rewarding aspect of all of this for me is being able to really see the impact that you are making on your client. You're really helping someone who's been through quite a lot of turmoil, and that you could possibly be their last call for help in respect to seeking asylum here in the UK. additionally, even as a qualified lawyer, it's been a really nice, welcome change of pace to review a completely different area of law and look into areas and cases that I've never studied or never come across before. Francis has been an absolute invaluable fountain of knowledge, and we've been able to pull resources together across the entire clinic where there are clear common themes popping up. So it's been a really, really interesting way to collaborate between both the two different firms and the students. As kind of already discussed, COVID has made kind of this whole experience maybe a bit more difficult, but actually the virtual aspect for us has made it a lot easier to just contact clients, contact witnesses at the drop of a hat. You know, there's no formal meetings having to go on. And even within our little team ourselves, being able to just jump onto Teams and ask questions and work together as a group every day, as and when, makes everything really easy and really collaborative. So it's been, so far, a great experience. I'll hand over to Olivia to see if she's got anything else to add.
Thanks, Paige. So I'm Olivia and I'm a lawyer at Clifford Chance. I'm part of the dispute resolution department. So very much like Paige, I'm not really working in an area that I'm used to dealing with on a day-to-day basis. I think I would definitely echo what Paige said. I think the client experience is really much our takeaway from this. It's the only chance I've really had to work closely with someone on issues that are so personal and so important to them. And I think also the important aspect for me has been to try and build trust. So a huge part of the process for us is trying to take a step back and realizing that this is someone who's been through the system, possibly a number of times, possibly, you know, they're used to dealing with, you know, authorities. They don't have a great amount of trust when it comes to that. So for us as well, we have this human element that you don't necessarily engage with in the same way in your corporate life. And there's very much an emphasis on allowing them to come to you, opening up and you know, being willing to put themselves in a position where they can give you the information. And actually on that point as well, the centre has been fantastic. So before we started, we were trained up, we were taught how to approach people with these points. Francis and Susie both, you know, taught us the importance of dealing with someone who, as we've heard from Francis, might have a lot of understandable mental health issues. And I think for us as well, to be able to come at that with a very pastoral perspective is hugely important. And just on the law side of things, you know, again, to echo what Paige said, it's a huge learning curve. You know, you're talking about a completely different area of law, but you do get to see the shape of cases very quickly. You see, you know, you're taken through, you know, their previous evidence. You start to build up as the trust comes. You start to build up the witness statement, and it's a unique position really as a lawyer and a fantastic one. So not only is it, you know, academically exciting, it's important. And I think, you know, the journey is very, very important too. And you do become invested and you want to do the best for the client. So I think it's fantastic. And I think, you know, the way that the clinic has been structured has been fantastic for supporting materials and for all of those things. So I volunteered, I think we both did, Paige and I, from the start, and I would like to continue to volunteer, and I would encourage others to do the same, because you'd be hard pressed to find something that has more impact, I think, than the clinic.
Well, many thanks indeed, Susie, Francis, Olivia and Paige, and congratulations again on all the fantastic work you're doing, and a special thanks to Olivia and Paige for being brave enough to talk about their experiences, particularly when I know a lot of our students are right at this moment doing or preparing for exams. So thank you very much for stepping in to speak to us today. As the final topical segment of this launch event, we've invited a panel of 3 expert speakers to share their views about the government's new plan for immigration and what this means both for asylum seekers and for legal advice and representation as offered by the Refugee Law Clinic. I'm really delighted to welcome, therefore, to our fantastic panel, Louise Hooper, who is a barrister at Garden Court Chambers and a member of the clinic's expert panel, Professor Elspeth Guild, an expert on asylum law from Queen Mary University of London, one of our partner institutions, and Kamena Dorling, Head of Policy at the Helen Bamber Foundation, one of the organisations collaborating with the clinic. Each of the panellists will give a very short presentation on the topic in turn, and then they'll be asked to respond to questions and comments that I'd like to invite you to post now in the chat box. So please don't be shy. If you'd like to raise a point or pose a question, then do type it into the chat box. And in the same vein, I just ask the speakers to keep half an eye on the chat box. So over to you now, first, our first speaker, Louise.
Thanks very much, David, and congratulations to everybody on getting the clinic off the ground and cutting the red ribbon. My background is that I've practiced in asylum and migration law for now over 20 years. I'm currently advising the Gender Equality Commission of the Council of Europe's drafting committee on migrant women in respect of a draft ministerial recommendation. And I've provided extensive training to migration and judicial authorities across Europe in conjunction with UNHCR and GRETA and Grevio. So GRETA is the Trafficking Convention group of experts, and Grevio is the Istanbul Convention group of experts. And having started in practice in around 1997 under the then new Labour government, I'm not sure that there's very much in the new immigration plan or new plan for immigration that is in fact new, save for those parts of it that are clearly incompatible with international law. Under the Fairer, Faster, Firmer paper of 1999, we saw the proposals introducing the one-stop system, which is touted in the new plan for immigration as a new thing, whereas in fact it's been around for almost as long as I have. And then other particular highlights of this new plan for immigration, which I think will affect the work of the clinic, include the proposals for things like the approach to be taken to credibility. So failure to claim in first safe country, or the requirement to tell the truth. And again, none of this is new. And you can see it, a lot of it set out in Section 8 of the 2004 Act. And so when you sort of start to dissect this, there are significant parts of it that are actually things that have been through the legal system over the past 20 years, many of which have been found to be unlawful, many of which have been found to be unworkable. And it's just a rehash in large part of laws and policies that are impracticable and inconsistent with our international obligations. And to highlight two of potentially the worst ones, leaving aside offshoring, which I suspect is so impractical that it won't actually happen. But the two that really stand out for me is the attempt to reintroduce a detained fast-track system. The detained fast-track system started with Oakington in 2002, 2003, has been as an accommodation reception system. And this attempt to fast-track asylum claims in detention has failed, has consistently failed, has been ruled to be systemically unlawful, and the attempt to bring it back in is going to be the same. And the result of that will be more fresh claims, because what we saw happen with the detained fast track is that you lose because everything happens so fast, and then you put in a fresh claim. And so for the last 5 or so years, that coupled with legal aid means that a lot of people have been preparing for the fresh claim rather than the original claim, because they knew it was going to fail. And the second thing in respect of accommodation centres is that we are yet to see accommodation centres that work. We're yet to see any that don't breach Article 3 conditions on a routine basis, and that provide safe and effective environments for asylum seekers to have their claims processed properly. So I have very, very serious concerns about the content of this policy. And the overall view that I have of it is it will lead to more and more fresh claims being necessary, notwithstanding the attempt to limit fresh claims that appears throughout the paper itself. Thank you.
So the paradox of the new plan for immigration. Many thanks, Louise. Can I pass over now to Professor Elspeth Guild for her comments?
Thank you so much, David, and many congratulations to the whole of the team, David, Susie, everyone who's been working on this. This is a fantastic contribution to the available resources for those who are among the most vulnerable in our society and the most in need of legal services, and yet often those who are the least able to access them. And I think that your emphasis in setting up the clinic to look at second and subsequent applications is particularly important. I say this because there's a 2020 opinion decision of the Committee Against Enforced Disappearances. The UK, of course, has not ratified that convention yet, but this opinion is in respect of a Sri Lankan in France. And the committee finds that it would be a non-refoulement for the man to be sent back to Sri Lanka, and notes that he made 8 subsequent applications in France with various different appeals, none of which ever engaged with the essence of his claim of his need for protection and the prohibition on enforced disappearances. And this is merely an example of what is happening across Europe in respect of the front loading of efficiency ideas into the asylum process. So no one, claims are made, badly prepared, no legal advice in advance, insufficient documentation, they're kicked back, subsequent applications need to be made, and extremely meritorious applications end up needing 2, 3, 4, 5, and in the respect of the case before the Committee Against Enforced Disappearances, 8 claims, before finally somebody was willing to look at the evidence and to recognize the need for protection. So tremendously important work. I'm very sorry to say that we have been singularly unimpressed by the new plan for immigration. At Queen Mary, we have brought together a group of experts in various fields. Some of them are professors in our own university, in other universities. Others of them are PhD students. And we have been doing a steady series of blogs, as well as participating in the Home Office's consultation on the new plan on immigration. And you can find those on the RLI website. We have some more that will be coming out. They're coming out almost every day, and we discover that we have an awful lot to say about it. I'm very sorry to say that we have very little which is positive to say about it. And I will finish by commenting that the attempt in the new plan for immigration to somehow crack down on subsequent applications is going to be a tremendous challenge for rule of law. But it's also merely a cut and paste from the EU's new pact on asylum and immigration, which was issued in September 2020. And if we had Brexit so that we could regain our own sovereignty, why are we just copying and pasting the worst aspects of EU proposals to align ourselves with the coercive and the rule of law antagonistic aspects of EU law? Thank you very much, and I wish you great success with your project.
Well, thank you ever so much, Elspeth. And I think you've really powerfully highlighted one of the contradictions that continues to plague many of the approaches to asylum in the UK and elsewhere. This idea that if you can get things done faster, then claims will be dealt with faster. But the faster you do things, ultimately the slower the claims end up being, and the more human suffering is involved. So a very, very important point. Thank you ever so much. I pass over now to our last of the panel experts. This is Kamena Dorling. Over to you for your comments from a policy perspective. Many thanks.
Thank you. And thank you so much for inviting me to be part of this launch. It's really great to hear about this much needed work and how much support there is for it. It's very heartening. I've worked in policy advocacy for about 15 years, and I'm now head of policy for the Helen Bamber Foundation, which is an expert clinical and human rights charity working with survivors of torture, trafficking, and other forms of extreme human cruelty. We provide a model of integrated care for survivors, which includes medico-legal reports, therapeutic services, legal protection advice, housing and welfare advice, and integration services. So I started actually as head of policy at the start of April. So basically my first month was spent trying to respond to the government's new plan for immigration, which is frankly not how anyone wants to start a new job. And it was particularly challenging because of the racist and divisive language that runs through that plan. I found it a really unpleasant document to read, and it's unlike any package of reform I've seen in my career to date. And I think what really struck me, having worked for many years looking at the immigration system and routes to settlement for those who are undocumented, was this very clear drive underpinning the plan to really extend the hostile environment agenda to the asylum and trafficking systems. It showed a kind of extrapolation of this Home Office, the long-held fixation of the Home Office with bogus asylum claims, and this kind of clear commitment to an approach which we know basically doesn't work, that says if you treat people badly enough, they'll either leave the UK or not come in the first place. And this is framed by a narrative which isn't new, and Louise has made a very good point about how none of this is new, that the asylum system is being abused by those who are either trying to enter the country illegally or are here with irregular status and are trying to evade removal. And so we see proposals like the creation of a two-tier asylum system, where if you haven't arrived by the extremely limited safe and legal routes that currently exist, you either wouldn't have your claim considered or you would receive a temporary form of status with reduced rights. And this not only undermines the very concept of asylum and the UK's obligations under the Refugee Convention, but what you're going to see is thousands more people living in a form of limbo, living in constant fear of return, and basically an increased casework burden on a Home Office that's already struggling. What I found particularly galling about the new plan is the failure to acknowledge that the existing backlog of 109,000 outstanding asylum cases is a result of the Home Office's own failings. It's not a result of people seeking protection. It's because the system's broken, and we don't see anything in that plan about how they're going to improve their own initial decision making. Instead, we just see frequent references to vexatious claims, repeated unmeritorious appeals, and attempts to delay removal. And so that's used to justify a suite of measures that would basically make recognition as a refugee much, much harder. And Louise touched on some of these, but obviously the proposals include a more rigorous standard of proof for recognition as a refugee, emphasis on raising all protection related issues at the start of the process, attempts to reduce access to expert evidence, and changes to assessment of credibility. For the Helen Bamber Foundation, these are all so pertinent to the survivors that we support in light of everything we know about the impact of trauma on how they might disclose what's happened to them. So refugees' ability to secure advice and disclose their experiences and basically evidence their claims can be really hampered by symptoms of depression, anxiety, post-traumatic stress disorder. And survivors of torture and trafficking really need time and a sense of safety before they can share what's happened to them. And this is already recognised in the government's existing guidance, but is seemingly completely ignored by the new plan. Olivia earlier talked about building trust, and obviously that's so vital. And too often we see those seeking protection aren't given the time that they need to build trust with lawyers. One of the things that we've really tried to emphasise in our response is the notion that late claims or fresh claims are by definition less valid and can be subject to a lesser form of judicial oversight is completely flawed. And this is demonstrated in the work with clients. Over the past 3 years, we've supported 178 clients who were subsequently granted status after making a fresh claim. And that's about just under 50% of our clients. It's our experience that it's only at the point of further submissions that often expert evidence is commissioned, and this can be of critical importance. And we find that many claims that would be initially seen by the Home Office as unmeritorious are successful once there's been proper scrutiny. So it's a really bleak picture, but it's one which shows just how important initiatives like this one are. And I really wanted just to sort of finish by kind of picking up on the point that Frances made about the impact of not having status and the impact of a precarious existence and living in limbo can have on people. And we see this all the time with the survivors that we work with. Stability is so central to their recovery, and often they can't even begin the process of rebuilding their lives until their immigration status has been addressed. So we desperately need the legal support that you guys are providing for individuals. And as a sector, we really need to pull together and push back as much as we can against the government's proposals.
Well, many thanks, Carmena, and that was an excellent run through of some of the policy-related issues that clearly are going to impact directly on those who you work with at the Helen Bamber Foundation, who are by and large victims of torture, some of the most serious cases. For those of you who are listening in, again, many thanks and welcome to those who've joined late. We've got three really leading experts here on the panel who are very well placed to talk about a range of different issues raised by the new plan for immigration. And I can see that we've got a couple of questions here from Sarah Singer. What are speakers' perspectives on the planned proposals to introduce cost orders in immigration litigation? Now, obviously, that's a concern for a clinic like ours. A second question from Lucy Hovell is about whether there are plans to go beyond providing legal aid to tackle some of the systemic legal and broader challenges that you've outlined. And I wondered if I might just pick up on that and pose a slightly broader question, that in the current political and social context of the UK, recovering from the pandemic and having its very particular take on immigration, what do you think is the right response? What avenues or pathways are there to effectively respond to a plan like this and the policy and legal measures that it envisages? How does one respond as a legal practitioner, Louise? How does one respond as somebody working on the policy front, Carmena, and Elspeth, from the university side of things? What's an appropriate response? Where do these kinds of reactions that we're talking about, where can they best gain traction? So if I could go back to the speakers and give you perhaps 3 or 4 minutes just to think through responses to some of those questions. If others would like to put questions in the chat box, or if there are any others that I've missed there, you're very welcome to respond to those too. So I'll go in the order that we started. Louise, over to you. You have the floor again.
Thank you. There's a whole lot of questions to unwrap in there. And the first thing that I'd say is that this plan and this consultation can't be seen in isolation. And it can't be seen in isolation from the already 2 consultations on judicial review that we've had this year, and the consultation on proposed modifications to the human rights legislation. And this is part of a package of measures which for me has at its heart an attack on the rule of law by the government, which I find deeply concerning. And our clients as asylum seekers and migrants are particularly vulnerable to attacks on the rule of law because they have no political power or political capital to get rid of a government at an election. They're also quite an easy sell for governments, which is what we've seen since the mid-1990s. It's a political vote winner to prey on vulnerable populations, particularly in times of economic crisis, and you're seeing that across Europe. So in terms of challenging it, one way is political, and it's about changing the narrative and the way that asylum seekers and migrants are viewed in society. And I think there is some sign that that's happening. I think that the government is potentially going a step too far, although I'm not sure that pendulum has swung round enough yet. But with the rise of the far right in particular, the attacks on migrant accommodation in various areas of the country, and the deportations policies, and the fact that people are becoming more and more visible, I think there is some scope for that. I think policy work's very important. From a legal perspective, I think the lawyers are all lining up at the moment, and you can see that in the responses that have been done by legal organisations and various barristers' chambers, including my own, tearing apart the inconsistencies between the plan and international obligations under human rights law. The problem with that is that it's unclear what's going to be done to the legal system, and where, if at all, there will be a legal space to challenge any of the legislation when it eventually arrives, and if there is, how that will be funded. So the proposals on those are quite vague in the plan. So although we would welcome the more front loading of the system and the provision of legal advice, it's not detailed how that's going to be done. And there was a final thing I wanted to say in respect of that on costs orders, because I think that is quite important. There's a really clear issue with one party to litigation deciding in what circumstances costs orders should be presumed. My very tentative view is that if costs orders were to be enforceable against the Home Office, that may well be the quickest way to speeding up the system and making it significantly fairer than any of the proposals in this particular plan. And I also think it would possibly bankrupt them. So that's a collection of ideas that might go some way towards addressing some of the problems. Thank you.
Many thanks indeed, Louise. Elspeth?
Thank you very much, and thank you very much for very thoughtful contributions. I agree entirely with Louise that the most problematic aspect of the direction in which immigration and asylum law is going at the moment is the attempt to remove it from the realm of law and to somehow push it back into merely administrative practice. And we see this in a whole variety of areas in respect of immigration and asylum. If we look at, for instance, economic migration, what used to be work permits, then the points-based system, now the tier system, there has been a tremendous effort on the part of successive governments over the better part of 50 years to ensure that that never became law, that that was administrative practice which was carried out. And I think what's happening in the field of asylum seems to be quite similar. The attack is on, of course, rule of law, but if asylum is no longer within the field of rule of law because it's an administrative practice, then it doesn't matter if there's no legal aid. It doesn't matter how poorly equipped decision makers are in respect of the kinds of decisions which they're making. So I think that that's a first problem. I would say that I think that this is really, the cat is out of the bag, that it's not going to be possible to push asylum back into administrative practice that is beyond the reach of rule of law. And therefore, your clinic is one of the keys to ensuring that the 1951 convention, the UK's ratification of that convention, and all of the panoply of the conventions prohibiting refoulement, which are now 5 at the UN level, continue to be applied and continue to be justiciable within the UK. Pro bono is obviously going to have to take on a more of the heavy lifting in respect of this as legal aid is increasingly squeezed out. And so the engagement of Macfarlanes and Clifford Chance and the other larger law firms in their legal aid programs, in their pro bono programs, is particularly welcome. Thank you very much.
Many thanks, Elspeth. Kamena?
Yeah, so just to come back to the how do we respond, and just to echo Louise a little bit, there's sort of 2 things we really need, don't we? We do need that bigger narrative change piece of work, and I think we need a kind of longer term vision of how we kind of shift public perception and campaign for a kind of general change of kind of public attitudes towards refugees and asylum seekers. And I think it can be difficult as a sector, and I use sector in the kind of broadest term, because so often we have to be reactive. So often we have to kind of respond to challenges that come up, and it can be really hard to step back and think, what is the bigger positive vision that we're working towards? But there are moves to do that now. And just last week or the week before, an initiative called Together with Refugees was launched, and that's very much one of the things that it's starting to do, is to think about how we kind of do that public facing work. And we're seeing many more groups led by refugees, led by survivors who can sort of speak out and do some of that engagement. So we have that, but at the same time, given that that's a much longer term vision, you have to do that defending the status quo piece of work as well. So what we're going to see coming out of the new plan for immigration is, obviously, we know from the Queen's speech that we're going to have the Borders Bill. We're not quite sure when. So there's going to be a lot of lobbying to do on that, depending on which parts of the plan are implemented that way. We'll have further consultations. The thing that unnerves me the most is we'll see yet more secondary legislation, and that's often so difficult to challenge because it doesn't get the right parliamentary scrutiny. And so I think it's about working as far as we can in coalition across the different areas to try and kind of have a united voice in pushing back. And it's going to be difficult because we have a government with a very significant majority, but it always has been difficult. Thanks.
Well, many thanks indeed. We've had one final question in the chat box, and I think it's an interesting one because it asks us to step back a little bit from the UK context and think about the extent to which international bodies might be something that is a useful weight to put behind some of the arguments that are being had. And the question from Devyani Prabhat is about whether the changes proposed in the plan for immigration might be taken to some kind of international body. I mean, it's partly a legal question, but I think it's also partly about how these sorts of changes position the UK following Brexit as an international global player, and what kind of example it's giving in terms of its commitment to rule of law, open, towards friendly relations with other countries, thinking about immigration, etc. So if I could ask the panelists in one final round of questions just to reflect about, what does the international aspect of this situation mean for refugees and asylum seekers in the UK? And if I can also just push you one final step further, and I know you've done this a little bit, but can you challenge us? I mean, in 1 minute, what would be one thing that a clinic like ours and students, volunteers and pro bono lawyers who are working with us could usefully think about doing above and beyond the everyday representation of cases? Are there other things that the clinic could be doing? And I think if I can just ask you very briefly to respond to those 2 points, then after that, we'll start wrapping up the discussion. So if I can take you in the same order again, Louise, can I go to you first very quickly?
Thank you. In preparation for today, I was reading through the UNHCR observations on the new plan for immigration policy. And the UNHCR have been working with the government over the last few years to try and develop new ways of processing claims. And they've made a very detailed critique of all of the areas where, in UNHCR's view, the new plan for immigration does not reflect the international obligations under the Refugee Convention. So to that extent, I think international bodies are already considering the implications of the plan, but what impact that will have on the government remains to be seen. I'm obviously, as you'll probably have guessed by now, very cynical about this, and I don't think it'll have any impact on them whatsoever. I think our sovereignty and what that means is, I have a very different concept of the limits of sovereignty to perhaps our leaders have. And unfortunately, I don't think they think that they sit within a global system constrained by international law. And you've seen that in respect to some of the actions taken post-Brexit that are not necessarily in compliance with the withdrawal agreement or political alignment with commonly understood international law. So I don't hold out much hope for that. And in respect of many of the international treaties that we're party to, we don't participate in the complaints mechanisms in any event. So I'm cynical about that. In terms of a law clinic, there are lots of areas of interesting legal issues and that I think might be of interest to the students. I think the one that's going to come up first probably in the context of fresh claims and asylum law more generally, is the proposals on strengthening the well-founded fear test, for which I read changing the well-founded fear test to mean something that isn't recognisable under the Refugee Convention. So the proposal, for people who don't know, is to require a person to prove on the balance of probabilities that what they're saying is true, and that the likelihood of them experiencing risk on return remains at the reasonable degree of likelihood standard. And that, I think, requires quite a lot of detailed and careful consideration for when the inevitable challenge comes. Thank you.
Many thanks, Louise, for that very detailed and useful response. Elspeth, would you like to say a couple of words?
Yes, I certainly participate in the comments which Louise has made, but I would say we need to remember that having left the European Union, the UK is now in quite a vulnerable position in the international community. It can no longer rely on being part of a bloc of 28 states, which has a real voice at the UN level and in international venues. Its position on the Security Council may indeed even be in question as UN reform goes ahead. I think that means that the emphasis that the UK has put in the context of the global compacts on refugees and migrants on being a good player and a leading player in the concept of a shared responsibility in respect of migration and refugees means that now to backtrack, its position is increasingly weakened. And those of us who participated in the global compact, stock taking, etc., were perhaps surprised at just how angry much of the rest of the world is with EU policies in respect of asylum. So the UK now in a weaker position, having embraced the compacts and now introducing coercive legislation, may find itself in a difficult position in terms of its international legitimacy.
Many thanks indeed, Elspeth, for those illuminating comments. Kamena, you have the last word.
Thank you. And I feel like I don't want to go backwards on what Elspeth has said, because I would be going, I don't know really what strength there is to the arguments about the kind of international frameworks and comparisons. It feels like, certainly in terms of modern slavery, the new plan is just going backwards on initiatives that the government would have paraded as kind of world leading. So it's hard, but I like the idea that there is mileage in that. So I'm gonna leave Elspeth's words on that. All I would say, in what more could people do who are involved in the clinic, other than supporting individuals, which is obviously so vital? I would say, please lend your expertise and your evidence and your voice to the broader work that's going to be going on to challenge these proposals, be that through kind of lobbying or further consultations, but also public awareness raising, public campaigns. We need to show that there is a kind of groundswell of opinion and fight back to what we've seen in the new plan. Thank you.
Well, many thanks indeed, Kamena, Elspeth and Louise, for your very insightful comments, and to everybody who posed questions in the chat box for your interventions. Just in closing, it's wonderful to be able to formally launch the new University of London Intercollegiate Refugee Law Clinic with so many of our partner institutions, staff, student and pro bono volunteer lawyers, and many others in attendance too. So thank you everyone for taking part and for continuing to support this crucial work. Looking to the future, I should mention that once the pandemic situation, not if, fully stabilizes, we hope to hold an in-person launch for the clinic, so you can get the chance to see the work we're doing firsthand and to chat informally, possibly over a glass, with or without a mask, with our staff, volunteers, and perhaps even clients. In the meantime, I hope you'll continue to accompany us in this really great work of clinical legal education, which is providing advice and representation to some of the most marginalised in our communities. If you've got questions or you wish to follow up, then please don't hesitate to email Susie Reardon-Smith, the clinic coordinator, at the email provided on her university webpage. Good evening to all, and many thanks once again.